has, in accordance with Article 1469 of the 1992 Constitution, removed the Chief Justice, Her Ladyship Justice Gertrude Araba Esaba Saki Tukono, from office with immediate effect. These are the opening lines of a statement just coming through from the presidency. And it goes on to give some detail that this follows receipt of the report of the committee constituted under Article 1466 to inquire into a petition submitted by a Ghanaian citizen, Mr. Daniel Ofori. After considering the petition and the evidence, the committee found that the grounds of stated misbehavior under Article 1461 has been established and recommended her removal from office. Under Article 1469, the President is required to act in accordance with the committee's recommendation. That is some breaking news coming through right now from the presidency. This is a statement signed by Phyllis Kwatiofosu. He is a minister in charge of government communications. The breaking news coming through is that the President, John Dramani Mahama, in accordance with Article 1469 of the 1992 Constitution of the Republic of Ghana, has removed the Chief Justice, Her Ladyship Justice Gertrude Araba Esaba Saki Tukono, from office with immediate effect. That's the emphasis. And this takes immediate effect. That's some breaking news coming through right now. This is a journey, the destination, as we're saying now, but a journey that has been ongoing. We've been going through this at least for the number of months gone by. But right now, this is the decision by the committee that was established under Article 146. And their recommendations have just been made known in this statement by the presidency. And it is on the basis of that, the recommendation of this committee, that the president has taken this decision to remove the Chief Justice, Justice Gertrude Araba Esaba Tukono, from office. This is the breaking news coming through right now here on TV3, also on TV3 Ghana on Facebook, and on 3FM 92.7. Dennis Pabewadam Esquire is with me right now, and we're going to get into it. Dennis, this is one that we've been on for quite a while. We started this journey months on, and this is the decision as per the committee as given by the president.
Rightly said, Alfred, and this is coming just few hours after the president received that particular report from the Justice Primma led committee, which sat on this particular case. They've indicated what has gone through, the committee has gone through, and what came before them, and how they arrived at that decision that they've arrived at. Except we are not told in detail what is contained in that particular report, but to the extent that the presidency is now reporting, based on that particular report, it can be reasonably inferred that it is the recommendation of this committee that the Chief Justice be removed. But Alfred, what is important to know is the basis for which the presidency indicates as the reason for the removal of the Chief Justice. When you look at Article 1461 of the 1992 Constitution, it provides the grounds for the removal of a Chief Justice or a Justice of the Superior Court of Judicature. And that particular article says that a Justice of the Superior Court or a chairman of a regional tribunal, in this case, the Chief Justice being a Justice of the Supreme Court, shall not be removed from office except for stated misbehavior or incompetence or on ground of inability to perform the functions of his office arising from infirmity of body and mind. Alfred, we do know that some persons have petitioned the president in respect of matters relating to what they say are stated misbehavior of the Chief Justice, for which they wanted the president to constitute a committee to look into.
That's right.
We have seen how we have gone through the whole process of the president together with the Council of State as stipulated under Article 146, having to determine whether or not those petitions themselves even merit the constitution of a committee to look into what is popularly referred to as Primma fasci case. That had been determined, a committee established, and subsequent to that, the president together with the Council of State again, invoking the provisions of Article 146, suspending the Chief Justice, and beginning the process to hear the petitions. We understand the report today has to do with one of the three petitions, and that is the Daniel Ofori petition, in which the petitioner himself had led 13 witnesses came before the committee to testify in respect of that. To her defense, the Chief Justice, 12 witnesses also came, including expert witnesses, to also testify in her defense. The end is that they've made their recommendations, and the president, having an obligation to act in accordance with the recommendations of that committee, has now gone ahead to to remove the Chief Justice from office. Alfred.
And it's a very, very, very fluid, detailed situation that we're following quite closely. This is breaking news. If you're just joining us here on TV3, also on 3FM 92.7, the breaking news, as we've been just giving to you, is that the President, John Dramani Mahama, has, in accordance with Article 1469 of the 1992 Constitution. We're going to go into the specific detail, Dennis, of Article 1469, because that also gives the exact powers that the President has exercised right now, and putting it in context that it is upon the recommendation of this particular committee's report that the President has taken this decision based on Article 1469 of the 1992 Constitution. He has removed the Chief Justice, Her Ladyship Justice Gertrude Araba Esaba Saki Tokono, from office with immediate effect. This follows the receipt of the report of the committee constituted under Article 1466 to inquire into a petition submitted by a Ghanaian, and then, as you've just mentioned, Daniel Ofori's petition. So that clearly indicates that it is specifically Daniel Ofori's petition that the committee found the merits in to make that particular recommendation on the grounds of stated misbehavior, which is one of three.
That is right. Because we heard the chairman of the committee earlier indicate why it is only the Daniel Ofori petition and not the two, because he explained that the petition and the second petition, together with the lawyers for the Chief Justice, had indicated they wanted an adjournment in respect of those petitions, for which that adjournment was granted. So they just had to deal with the Daniel Ofori petition, and then the two are still pending. However, as it is now turning out, it does appear that those petitions may never be heard again, because what will be the end goal again? So that's the information that we're just gathering. And Alfred, if you would oblige me, let's go back into memory lane, just to see how things have panned out over the period, knowing very well that these three petitions are not the only petitions that have come the way of the former Chief Justice, if I may not call her so, in respect of persons who were seeking her removal. We do recall that as far back as January 6th, just a day before the previous administration left office, the President had rejected petitions for the removal of the Chief Justice then, describing him as being deficient. But fast forward to March and the new administration, three petitions, including the one we are now discussing now, for which a report has been submitted, and the President acting on that particular report, were also submitted to the Council of State. The President went ahead, together with the Council of State again, invoking the powers given to the President and the Council of State under Article 146 to suspend the Chief Justice. Then a 5-member committee was put together that was chaired by Justice Scott Palmer to look into the merits of that particular matter. Then I need
to hold on a bit there on that 5-member committee's establishment, because it is on the basis of this committee's recommendation that the President has taken this decision. And we have a video, in fact, that captures that moment that the chair of this 5-member committee, Justice Gabriel Scott Palmer, presented this report of the committee, this 5-member committee, to His Excellency the President, John Dramani Mahama. Let's take a look at that video right now. Just a moment.
Ladies and gentlemen, Mr. President, in March this year, you received 3 petitions pursuant to Article 146 of the Constitution 1992 for the removal of Chief Justice Gertrude Asaba Araba Sakitokon, and the public was made aware of these facts. Subsequent processes dictated by the Constitution and the decisions of our Supreme Court were gone through, culminating in the establishment of our committee under Article 146, Clause 6 of the Constitution. The nation was further duly informed, and when we commenced our work on the 15th of May 2025, the Minister of State for Government Communications was briefed to notify the public about it. There has been considerable interest in our work, shown through comments and opinions by Ghanaians and international observers as well. However, the committee restrained itself all along from reacting, even when blatant false statements were made about members of the committee and our work. To the committee, our mandate and remit is set out under Article 146, clauses 7 and 8 of the Constitution. It's clear, and it is to inquire into the petitions in camera, hear the person against whom the petitions have been brought in her defense, by herself or by her lawyer or other aspect of her choice, and then make a recommendation to you, Mr. President. As I have said above, 3 petitions were referred to us. And though all 3 petitions seek the same relief, each petition is distinct and would succeed or fail on its individual strengths or weaknesses. Mr. President, without disclosing the substance of the proceedings, and since in-camera proceedings is not the same as in secret, we can state that in respect of the first petition, we received evidence by Mr. Daniel Ofori, the first petitioner, through 13 witnesses. Similarly, the Chief Justice in her defense called 12 witnesses, including expert witnesses, as she is entitled to do under the Constitution. The Chief Justice testified personally and was cross-examined. The committee received about 10,000 pages of documentary evidence from both sides. There were 4 lawyers that represented the first petitioner, Daniel Ofori, and 4 lawyers represented the Chief Justice. Mr. President, after critical and dispassionate examination and assessment of all the evidence, including the expert evidence, against the provisions of the Constitution and the relevant laws, we have, without fear or favor, arrived at a recommendation on the first petition. The recommendation is contained in the envelope which I now give to you.
So that is exactly what happened just a few minutes ago. In fact, this is fresh on the plate, what you're just seeing right now, with the chair of this 5-member committee that was charged with the responsibility under the Constitution, specifically detailing their work in the provisions of Article 146, and that's Justice Gabriel Scott Pomang presenting the report to the President for on behalf of the members of the committee. You had the likes of Daniel Yardomelovo, a former Auditor General, who's the chair of the Economic and Organized Crime Office as a YOCO board now, together with some other distinguished persons who served on this particular committee, this 5-member committee. Then as you hear, the chair of this committee detail the work of the committee, what they've done over the period. That's led to this particular decision that has been communicated now to the President, and the President also communicating to the members of the general public, Ghanaians, as well, through this statement that we have just put on the screen. So that's the details of it. That's the breaking news right now. So this decision was guided by the Constitution every step of the way, is it not?
Yes, and Alpha, just to add that you also hear the chair of the committee also indicate that while they were doing their work, there were also some allegations made against them, but that they focused on their work and they got it delivered. And that's very important because when you look at some of the legal hurdles that this committee had to cross or that had to be dealt with for the committee to do its work, some of them had to do with some of the members on the committee, particularly the chair of the committee himself had been specifically named in some of the lawsuits, and the other chief Supreme Court justice who happened to be on that particular committee. Also, there has also been an instance where the entire membership of the committee had been challenged, and that is part of the things that we're looking at. So the first legal action that came against the committee was that was brought by Vincent Ekosafwa, the old Tafu MP. For him, he thought that the parts of the Constitution, especially Article 146, some interpretation be placed to indicate what the procedural line should be, because his argument essentially was that once the President received the petitions, he ought to have given copies to the Chief Justice, and that for the fact that that did not happen, it was an unlawful procedure that was adopted.
Yes.
Subsequent to that, he brought an application for injunction seeking to stop the committee from doing its work. On May 7, 2025, the Supreme Court dismissed that particular injunction application. It didn't end there. By May 21, 2025, the Chief Justice herself files a writ of summons challenging the legality of her suspension. Mind you, by this time, she had been suspended, and that she also sought an injunction to halt the committee from proceeding its work. Part of the averment in this particular process was to the fact that some of the committee members had vested interest in the matter, for which they should not have been part of the committee.
Yeah.
By May 26, 2025, the CJ filed an affidavit. This was a supplementary in which she made some allegations of mental torture. She said that there was bias against her, and it was in this particular one that she made reference to the fact that the way in which the committee was going about its work, including how she was even searched before getting to the premises in itself, was problematic. However, this was not admitted in evidence because clearly the argument from the side of the Attorney General was the fact that this is supposed to be something that's supposed to be in camera per Article 146, and that was not even allowed in evidence in the first place. Fast forward, Alfred, May 28, the Supreme Court, in a unanimous decision, rejected the injunction application that was brought by the Chief Justice herself. Mind you, even before the Chief Justice had come, 3 earlier ones, including the Vincent one, had been dismissed. By June 2025, there was a press conference that was addressed by the Chief Justice herself, in which she addressed a number of issues, including reiterating allegations of bias and how the whole process had been impugned, for which she did not think that it was fair to her. Fast forward, by July 4, 2025, she filed the case at the ECOWAS court, by which time she was demanding 10 million in damages for what she says that was not a right process. The Human Rights Court heard the application. They are yet to deliver their judgment on that particular one. And this was in respect of the ECOWAS court. That was not done. She went back to the High Court, this time around, filing a judicial review, basically challenging the procedure that had been adopted by the committee, and also alleging the breach of human rights.
Absolutely. And these are cases that are still in motion, and the courts have not determined the outcome of it.
Yes, for the substantive ones, yes, but the injunction applications, those have been determined and
already
dealt with.
Perfect. And let's stay the steam on that, and let's go on to Zoom right now. Martin Pebo is private legal practitioner, and is one that we've been engaging right from the beginning of this entire process, where 3 petitions at the start, that's what we were told at the start of it, 3 petitions were received, and it was the first petitioner, Daniel Ofori's petition, that formed the basis for this recommendation by this committee headed by Justice Gabriel Scott Primma, whom you see right there presenting the details of this report by the committee to the president. In that brown envelope, the president received it. You have all the other members of the committee as well seated at the table with the chair, Justice Scott Primma, who presented it, the Chief Justice, that's the Chief of Staff as well, was there. And Martin Pebo is joining us on Zoom right now as private legal practitioner. Counsel, good evening. Thank you very much for joining us. And when we started this conversation months ago, you had indicated that it would have served the now removed Chief Justice some good if she had resigned right from the beginning of this. Well, the process has gone full scale, and this is the outcome. The president has communicated a decision to have her removed from office based on the recommendations of the committee and their findings on Daniel Ofori, petitioner 1's petition. Counsel.
Yes, well, so like they say, the law is the law. So at this juncture, the law has taken its course, and so that will be it. We're hoping that this will bring closure to this case so that we can, go on to concentrate on other matters of improving the judiciary. Yes, I mean, my position, as I said earlier, I was hoping there would be a window for her to resign way from the beginning. but, it didn't happen. Also the Supreme Court too had held that in the Justice Utaderi case and also in the Frankie J. Chum case, that once they start the hearings, then the respondent, that's to say in this case, the Chief Justice, has no right to resign. I was hoping there would be a political settlement that would have resulted in a resignation. But as I said, that was hope. But all of that didn't materialize. So once the committee is done with its work, and then that's based on the first petition alone, and once she's been removed based on the first petition alone, that's it. We will see whether the committee will have the appetite to go into the other two petitions. It doesn't appear it will be a good use of our time, but that's just my personal opinion. Let's see how it goes. So Article 146, well, that's been it. We're hoping also that going forward, the Constitution Review Commission, based on what we've seen in these proceedings, would strengthen the provisions to make them better in future. I think that's what I can say for now.
And you're saying indeed the case that the decision of these committees to have the Chief Justice removed was on the basis of the details of the first petitioner, Daniel Ofori's petition. So the other two, you'll say that, in your view, it would not serve the good of time if the committee goes into the other two?
Absolutely. Absolutely. Yes. Because right now, she's been removed. And so once she's been removed, I'm wondering what good it would do to continue the hearings. But in law, well, it's allowed, because once the cases are still before the committee can go on. It would also be within the right of the petitioners to withdraw, to say, look, okay, if Madam Tokono has already been removed, they want to withdraw from having their cases heard. Yes, so that maybe, because you see, I'm saying this because let's not also forget, Madam Tokono is fought this case every step of the way. My colleague, Wedam Puabri, has already, gone through, both of you have gone through the milestones, the, filing a case in the ECOWAS court, now the final one being the so-called group of the Bar of England and Wales jumping in, a letter that a lot of us had issues with in terms of its authenticity, not being signed, and the language in the letter, etc. But whatever it is, there was such, traction, that at every point she sought to fight back, and the various fora, etc. she's been through have resulted in a way, in giving us bad press. We can't run away that we've suffered bad press, a reputational damage to the brand name Ghana, because you see the kind of things that the so-called Bar of England and Wales wrote in their letter, the Commonwealth Lawyers Association also wrote earlier on. You see all that language taking us to the ECOWAS court, all those things, and the allegations of bias and all that, they've hit us. They've damaged us a bit. So for me, usually, if you can avoid litigation, avoid it. It's even in the Bible. And the Bible says that, hey, if your brother, somebody is taking you to court and you can settle the case on the way, settle it before you go and then you get thrown into jail, right? There is something like that in the Bible. So in this case, we are looking at protecting the brand name Ghana. We are quite a strong democracy in this sub-region, but globally, we are still a fragile kind of democracy. So when there are issues like this being circulated internationally, it reinforces the notion that we are still not that much capable of running our own affairs. So it's in that context that I was hoping that maybe the second and third petitions would not be gone into, so that we can, have closure.
But you made the point about the Chief Justice challenging this process every step of the way. And the details as Justice Puaman gave today complements that point that you made, because the committee had evidence from 13 witnesses on behalf of the petitioner. The Chief Justice, well, the now removed Chief Justice, also testified and was cross-examined. She called 12 witnesses, including experts. In total, the panel said they received approximately 10,000 pages of documentary exhibits from both sides. Each side was represented by 4 lawyers. It's a very meticulous process we've seen play out up until this point, is it not?
Yes, absolutely. Yes, it's been grueling. Yes, because, you know, to have 30 witnesses for the petitioner, 12 for respondent, 25, and you see each one of these was given evidence, so that's what we call evidence in chief, right? Through the witness statements that the witnesses filed, then cross-examination. So cross-examination of all these 25 persons. It's a lot. It's a lot. It's not a joke. That's quite a robust process, rigorous and robust. And of course, it's taking a toll. Yeah, because from dispatches that we could hear, you know, for them to have finished this quickly, they would go in the morning and close in the evening. So it was usually a full day's work, you know, morning to evening, right? A number of days in the week. So it's been a lot of work. It's been a lot of work. Yes, that one we can't run away from it. And in natural fact, we should commend the committee and everybody involved for cooperating for this work to be done in such a time.
And we know that the Chief Justice has a dual role. I mean, as a judge or a justice of the Supreme Court, and then also the head of the judiciary. Now, she's been sacked as the Chief Justice, essentially the head of the judiciary. What happens to her role as a justice of the Supreme Court?
Okay, yes, so with this, it goes the two of them. Yes, it goes for the two of them because it's not that she misbehaved as Chief Justice separate from being a justice of the Superior Court, right? No, they touch both offices because yes, she's a judge of the Supreme Court and also at the same time Chief Justice. The matters that were raised are matters that if a judge, ordinary judge, were involved in and then there was evidence against that judge, the judge would be removed. So in similar vein, since the Chief Justice is a justice of the Superior Court, and when we say Superior Court, that's High Court, Court of Appeal, Supreme Court, right? Yeah, so it's the same thing for Chief Justice and for any other judge of the Superior Court. Okay, so it can't be that she's been removed as Chief Justice, but she would come and continue as a Supreme Court judge. No. The law doesn't allow a Supreme Court judge to be engaged in the matters that were alleged to have been engaged in.
I see. And Counsel, stay on for me, if you will, just so we backtrack a bit. We recall exactly what the position of the now removed Chief Justice Gertrude Tukono was on the petitions brought against her when she addressed the press conference detailing her concerns a couple of months ago. Take a look.
Unfortunately, every step of the removal process being undertaken against me is being done in a manner that breaks every rule on how justice is delivered in our country. And this is why I find the need to draw the nation's attention to the serious violations of the Constitution and law in the process, and the danger it holds for the development of the nation's democracy.
That's Gertrude Esaba Tokono, and the decision to have her sacked is what we're getting into. It's a breaking news that came through some few minutes ago here on TV3. It's a statement from the presidency detailing reasons why that decision has been taken as upon the recommendation of the 5-member committee that was established under Article 146 to look into the petitions against the then Chief Justice. And it was the details of the first petitioner, Daniel Ofori, that the committee made their recommendation on to have her sacked, and on the basis of that established fact of stated misbehavior. Martin Pebu is private legal practitioner, is still with us. Dr. Joshua Zato is a political analyst, a lecturer, senior lecturer at the University of Ghana Political Science Department, joining us as well. Dr. Zato, good evening. Thank you for joining us.
Good afternoon, and thanks for having me here.
Well, also, you had made the point about the Gertrude Esaba considering resigning right from the beginning of this process. She had a response for you and others who were making that suggestion a few months back. She says that that was really not an option on the table for her, and this was why. Take a look.
Yeah. Resigning or retiring while Article 146 proceedings are being conducted to remove a judge is not an option any judge or public official can even have. There is a decided case on the matter by the Supreme Court. The suit number is J6/02/2019. Again, no one has the authority to walk away from proceedings started by the state. Judgment can be entered against you because you fail to defend yourself. And a judge who resigns or retires would still lose all entitlements that they have worked for because they failed to defend the claims and resigned or retired while the proceedings were still going on.
Well, so that was it. Look, this was even an option on the table for anybody going through the process because you stand the risk of losing your entitlement. Now, with this decision that has come, does that risk also now really play out in this case, that she stands the risk of losing all her entitlements after being sacked?
Absolutely, yes. So she loses all her entitlement because the meaning of the sacking is that she was sacked on the basis that she's been found culpable. She's been found liable to have breached certain rules, okay, whilst in office, right? Now, I'm sure with time, we will get to go into the rules, right, when the decision is made public, because in the Justice Derry case, the Supreme Court said after the decision is out, that's after the proceedings are completed, the secrecy or the in-camera protection should go off. So we'll plead with President Mahama to give us a copy of the report of the committee so that we will see what findings were made. Because in the Justice Derry case, the Supreme Court was very clear that after the decision has been made, that cloak of in-camera protection, the secrecy, is no longer necessary in a democracy. It's no longer necessary in a democracy. And the Supreme Court went ahead to compare the cases in South Africa and other countries, right, around the world. So the Supreme Court is very clear that the decision can be made public, that's the committee report, etc., after a decision has been made. It's not meant to be kept secret. And in this particular case, even Justice Tokonu herself had waived her right, but eventually it was generally agreed that even though she waived her right to an in-camera hearing, it was agreed that based on the decisions of the Supreme Court, etc., the provision in Article 146 asking for in-camera hearing was not meant to benefit Justice Tokonu alone. It was also to protect the whole system. So it was agreed that the proceedings should continue in camera. But now that the proceedings in Petition 1 have terminated, in the Justice Derry versus Tiger IPI and Attorney General case, the Supreme Court said afterwards we can get the details, get the petitions, get the reports, so that we can dissect and see where everything went well, and if some places didn't go well, naturally people will comment so that tomorrow we will not repeat such mistakes. Yes, so Mr. Okanse, that is it. And now when it comes to the matter of there was no option to resign, remember that I said that if we wanted to get a resignation, there are 1,001 ways of doing it. But as I said, right now, we've gone past it, so it's no longer possible. So let me tell you what I was thinking. You know, matters like this, it's a civil case, right? So there could have been an agreement that, look, okay, I want to settle this case. I want to resign. Like, can I do a resignation letter for you to see so that then you will withdraw the petitions? Then she would have walked away, okay?
Right.
But as we're saying, it's because the Supreme Court said when the proceedings start, you cannot resign. There are two Supreme Court decisions. And I was saying that, oh, because she's Chief Justice, at that time I was scared of all the places she was going to go to. Remember the time I kept saying we should allow for resignation? You know, that time she hadn't gone to the ECOWAS court. And at that time too, she hadn't, the bar of England and Wales hadn't jumped in. So you remember we had seen that the way she was fighting it, we're going to suffer more embarrassment. So I was looking for a political settlement. And so sometimes, you know, they will tell you that the law was made for man. But, I mean, bottom line is that generally it looks like not many people sided with the resignation thing. It's a democracy, so we'll go with the majority. You remember also, yes, Lawyer Ansasari also supported the resignation route because we could have saved there and then, you know, so there could have been a settlement. This is a Chief Justice, so this is a Chief Justice, not any other Justice of the Superior Court. She's a Justice of the Superior Court and specifically Justice of the Supreme Court and also Chief Justice. So, I mean, to every rule, you hear there's an exception. But bottom line is that it didn't work. So we use the law, strictly speaking.
Right.
And like Justice Tokonu herself had said in the past, the law is the law. So, I mean, we have to abide by it. Sometimes the law is difficult. It's painful to abide by the law, but the rule of law demands that we should abide. Yes.
Indeed. Amas Bebo, thank you. And kindly stay with me. And this I bring in Dr. Joshua Zato. You had also indicated that for you, the Chief Justice was a goner, even before today.
Oh, you remember that, right?
I do, because you said it so many times without number.
I thought you forgot. Alfred, I'm a soothsayer. I should be a soothsayer of something, or a prophet. You know, they should call me Prophet Jebunti. Let people come to me, I'll prophesy for them, and I'll make some money, you know? That'll be a good thing. I should be a prophet or something, you know?
You sound fulfilled.
I did. I called it. I told you, listen, the Chief Justice was an impediment. She was a means to an end. The end is the EC chair and her deputies. And I'm going to make another bold, prophetic, angelic prediction today. They are next. Very soon you will see the petitions for the removal of the EC chair and her deputies will roll in. And I'm telling you, by the end of the year, the CJ has gone, the EC has gone, the whole slate is going to be swept clean, and then you are going to have NDC people planted there to continue the NDC process of going forward. So yes, I'm very, very certain about this, and it's going to happen. Just watch this space. Well,
but then, as was clearly indicated, this is a constitutional process that was at play, specifically detailed in Article 146, as we've seen play out. And the President's decision was based on the recommendations of a committee, and he did not take that singular decision. Dr. Zato.
I have no problem with the constitutionality or otherwise of it. But you also then realize that every aspect of it, every single phase of it was what? Laden with politics. Now, this is what history will remember. History will not remember constitutionality, no. History will remember that under this constitution, in this Fourth Republic, it was His Excellency John Dramani Mahama who was the first to fire a sitting Chief Justice, a member of the co-equal arms of government. History will remember that. History will not forget. Tomorrow, I'm sure that if people start teaching law, constitutional law and other laws, they will always bring this up. And whenever they bring this example, they will say, His Excellency President John Dramani Mahama removed the Chief Justice Tokunu. And so far, it is probably the biggest achievement of this government is the removal of the Chief Justice. And that is what history is going to remember. And that is what politics is going to remember. And that is what going forward, everybody is going to remember. So you can call it whatever you want, or you can label it whatever you want. You can hide under every single judicial or legal interpretation, whatever. But the history will remember the Chief Justice was removed by His Excellency John Dramani Mahama, and it's the first time it ever happened.
You've indicated that you have no problem with the constitutional provision as it played out in this instance. And it is
because
the same.
There's nothing I can do about them.
Yes,
Alfred, I cannot change the constitution.
I was coming to a point. And it is the same constitutional provision that you don't have any problem with, that also empowered the president to take this decision based on the recommendations of a committee established under this same provisional constitution, the constitution of the republic, that you are not having a problem with. So how then do you say that it's a decision that the president has taken to sack the Chief Justice without also taking into consideration the provisions of the Constitution that detail the process that has resulted in this decision today?
No matter how you call it, you say it was His Excellency President John Dramani who sacked the Chief Justice. That's a fact. It doesn't matter whether it's a constitution or not. He sacked it. He wrote the letter saying, you are sacked, you are fired. One. Two, I've also explained on previous occasions, maybe I should rehearse it now, the whole process was laden or interwoven with politics, and it is the politics that we've seen coming up. We can rehearse some of them. One, the reason why we do not see the Council of State's charge sheet, we didn't see their recommendations, is a political decision. Akufo-Addo showed us the Council of State reasoning. President Mahama did not. That was a political decision. Two, when the decision came, the decision to suspend the Chief Justice was a political decision. It was a judicial decision, because the president could have still exercised his discretion, allowed the Chief Justice to stay in office while the committee decided the case. That's also political. Three, even when to submit the report to the Council of State was also political. The president could have received it and say, yes, I've received it, but he could have kept it for as long as he wanted, because the Constitution did not say you must submit it to the Council of State within a week, within 2 weeks, within 3 weeks. It was up to him. So I'm saying that in all these instances, and even the decisions of the Council of State, remember, it was the National Communications Officer of the NDC that announced the verdict of the Council of State to us. The Council of State never told us. He was the one who told us that the Council of State voted 30 to convict and 1 abstained. That decision to leak the information, to get information up to the communications director of the NDC was so political. So I'm saying that every single step of this process had politics interwoven into it. The discretionary powers being exerted were political and partisan. So you cannot decouple the politics from the law or the Constitution in these cases. They were in tandem, they worked together. The politics was used to grease the wheels of the Constitution, of the law, so that these things will go faster.
I see, but then the fact that you conclude with that statement that this for you is a political decision, even though, as you indicated, you acknowledge the constitutionality of the process. Those are two very different positions that do not merge at any point. If the constitutional process details... I'm coming to a point. If the constitutional process details what was at play, what could the president have done, really?
So, and I've just told you what the president could have done. One, the president could have taken once he received the thing, the decision on when to send the Council of State was up to him. He could have kept it and not send it there. Acknowledge receipt of it, never send it there. He could have done that. Two,
no,
when the council,
you're saying that power rests on him. There's the provisions of the Constitution.
When he can submit it.
No, that's what I'm saying. If you are abreast with the details of Article 146 from 6, Clause 6 all the way, you would understand why maybe the point you are making also would be a bit problematic in the sense of what the provisions of the Constitution is. So that if the president receives the petition, the process starts. He is
Yes.
bound by that constitutional provision. So you don't say that he could have, decided not to forward it to the Council of State. That's not
when
written in
he's-
the Constitution.
He gets to decide when to forward it, right?
The Constitution mandates him to do so.
Good, but the Constitution tell him when to do it.
But that's what I'm saying, that the process just plays out after the receipt of the petition.
So the process, I'm saying that how fast, or in this case, how fast or how slow the process goes was then determined by presidential discretion.
But that's the Constitution at play, regardless of the discretion of the president.
So you see, again, so you and I seem to agree on the same thing, that look, there is constitution, I'm not saying, but then there's also politics. Again, listen, he received the report today, we are told, fired the woman today. He could have taken some time to study it better and fire the woman later, right?
But
He could have done that. That's also discretion. Secondly, I'm saying that. Go ahead. Let me hear your question.
well, so that I continuously reference the dictates and the details of Article 1466, which you acknowledge. You say you don't have a problem with that. But then again, you say that the president could have exercised discretion. And I'm telling you that the dictates of the Constitution, as stated in Article 1466 to 10, does not necessarily give some room to the president's discretion. The president is bound to follow the dictates of the Constitution. That's what I'm trying to bring your attention to. But this is where I bring in... hold on a bit for me. Hold on a bit for me. Lawyer Christian Mamhesi is joining us as well. This is private legal representative. And so, can you hear us? Good evening.
Yes, good afternoon, and thanks for having me.
And this is why I bring you in about this, the position of the law and how this process has played out. Dr. Zato is of the view that it's the discretion of the president at play, dotted in the exercise of the constitutional provision. The point I was just trying to draw his attention to is about what the dictates of the Constitution is, that when the petitions are received, the process kicks in and the president is bound to do so. Is that the position of the law?
Yes, I mean, rightly so. When the recommendations are received, the law does not put time limitation on it. But I mean, I can understand where he's coming from. And that gap could be filled by political inferences. But as far as the law is concerned, there is no time gap. The president, upon receipt of it, could act immediately, and that's what he did. And there's nothing unconstitutional about what has happened.
I see, and this is the process that has been at play until now, that we've seen the outcome of this particular process with the decision to remove the Chief Justice after the recommendation, or upon the recommendation of this 5-member committee, which submitted its report to the president earlier today. Is this one that you expected as well, based on the knowledge you have of the details of this petition, specifically the first petitioner's petition upon which this decision was taken?
I mean, because the matter was heard in camera, it would be prejudicial or difficult for anybody to speculate what the conclusion of the committee would be. And just as we have it, it's in camera as required under Article 1468. And given the period of time, there were parties or persons who testified for and against the learned Chief Justice, as we got from the news portals and all of that. But as to what the testimonies were, to us again, run the probative value in what they put out there. So probative value basically means that the evidentiary weight in what was put for and against the removal of the Chief Justice is quite unknown, but the conclusions of it would be before, or as it were, before the president, and based upon Article 146(7), the president has taken a decision to remove the learned Chief Justice.
I see. Now, we've seen this process play out till now, and we also do know that the Chief Justice decided to take a case to the ECOWAS court. That court has not delivered a ruling as yet on this particular case there. Does the ECOWAS court have any jurisdiction whatsoever to, as it were, vary the outcome of this committee's decision?
Oh, yes. I mean, because of the fact that Ghana is committed to the ECOWAS Treaty and the amendments that were made early in the 2000s, Ghana is committed to the ECOWAS court. And for whatever decision that the ECOWAS court would reach, Ghana will be amenable to it, based upon human rights infractions, if only they conclude as that.
Now, I was asking earlier about the options that were thrown at here at the beginning of this entire process by the likes of Martin Kpebu, whom you were with earlier. His point is, he made earlier was that the Chief Justice, now sacked, could have saved herself all the trouble of going through this entire process by stepping aside right at the get-go. Now, the sacked Chief Justice was of a different view, that if that had happened, she would have lost all her entitlements. Now, we do know as well that this particular decision is what the law captures. But stay with me, Lawyer Mahama. I have the Minister in charge of Government Communications, the Abrasegu Kwamankese Member of Parliament, Phyllis Kwatiofosu, who signed this statement announcing the sacking of the Chief Justice, joining us on the telephone right now. So Kwatiofosu, good evening. Thank you for joining us.
Oh, good evening.
Now, we saw the committee members submit their report to the President moments ago, and then this decision communicated. I want to find out from you, first of all, whether this particular development today is one that, in the end, brings all of this to a close. We're moving forward.
Well, I believe so, except to say that the chairman of the committee, in the presentation of the committee's report, stated that there were two outstanding petitions that they had not looked into because they had received representations from the parties involved for an adjournment of hearing into those matters. But with respect to the Daniel Ofori petition, there was no such request, and therefore they proceeded to look into it. And it was on the basis of their work on that petition that they have recommended the removal of the Chief Justice, which the President has done, as communicated in the statement that I issued a while ago.
I see. And so the other two petitions, any indication that the committee is minded to getting to it, or because this really is the ultimate outcome, that if the process had played out, either or not, or whether or not she was going to be removed or otherwise, now that she's been removed, well, the likes of Martin Kpebu say that the committee should not waste their time getting into the other two. Any indication of what the committee's decision is on the other two?
Well, government is not in a position to dictate to the committee how they should or when they should do their work. So it is entirely within the purview of the committee to decide what to make of the outstanding two petitions. But the President has acted strictly in accordance with the constitutional stipulation that enjoins him to carry out the recommendations of the committee. That is what has happened today.
How do you respond to the likes of Joshua Zato on the other line, who says that all of this process was dotted with politics, even though it is stipulated in the Constitution?
Well, being an MPP partisan, you would expect him to take a position similar to what his party has taken. If he doesn't furnish any basis for that position, except to make it, just like his party propagandists and members have done. But everybody who is fair-minded and has followed this process will be clear in their minds that the President has stuck strictly to constitutional provisions. As of the MPP, they can abrogate and reproduce that when they want. When they were in power, the same Article 146 was used to remove the then head of the Electoral Commission, Madame Salazar, and two other deputies. I didn't hear Dr. Zato offer a whimper on that occasion and express any belief of political motivation. Suddenly, political motivation has been invented by him to smear this process in order to achieve a certain political end. I don't think that is the kind of discourse or commentary we should be having on this particular matter. Let Dr. Zato and the rest of them in the MPP point to any specific infraction on the part of the president in respect of his handling of this matter. He will find that, and indeed till date, nobody from the account has been able to point to any infraction, or no other person in any quarter within our society has been able to point to any infraction. That shows you clearly that President Mahama acted above board. He has acted within the remit of the law, and that is what the law says should be done.
I see. Well, it says the president could have exercised some discretion in the pace at which this was executed, and that really, after receiving the petition, he could have decided not to forward it to the Council of State.
How so?
That's
that all read the Constitution. Which part of the Constitution is that the president can decide not to forward it? The Constitution is clear that upon receipt of the petition, the president shall, in consultation with the Council of State, determine Primma fasci. That is the word of the Constitution. How then does Dr. Zato decide on his own that the Constitution should be disregarded because he believes that his party must show their support behind the Chief Justice? I don't think that we can, as it were, entertain that kind of logic.
Okay.
It is completely wrong. What he is asking the president to do is a violation of the Constitution. Indeed, the president will be liable for removal from office if he fails to act in the way that he acted.
Okay, Mr. Kwacho, so order the best. Dr. Zato, yeah. So, what was the?
What do you call it? Happened. You called me to have a debate. You called me for a debate.
No, not at all. Yes, but
as you can imagine, there are many.
There are quite a number. Yes, I respect that, but I just want to find out from you, and let me stay a bit for. And Dr. Zato, I'll come to you. Yes, but now that this decision has been communicated, when will the process for the substantive Chief Justice be named start?
Yeah, I think that it is only a matter of time. The consultation of the appropriate authority, the president will make the appointment. Then it will be communicated to the people of Ghana.
I see. Dr. Kwacho, appreciate your time, and I thank you so much for joining us.
The pleasure is mine, yeah.
Felix Kwacho is Minister in charge of Government Communications, and then also the Member of Parliament for Abrasebo Kwamankase constituency. And Dr. Zato, yes, you were quickly, and then I'll acknowledge a few persons joining us. Yes, Doc.
Should not submit the report to the Council of State. That was wrong. I didn't say that. I said the speed with which he submitted it to the Council of State was based on his discretion. He has to submit it, but when he chooses to do that, it's based on discretion. That's what I say. So if you say, I'm not a lawyer, but I can also read the Constitution that says that the president must submit it to the Council of State. But when he chooses to do it, it's based on discretion. So the way you presented it to Felix was wrong. That's not what I said. Secondly, I also did make the point that the decision to release or not to release the report of the Council of State was also based on what? Discretion.
I think it was quite clear at the point I made that you indicated the pace.
That wasn't what Felix said.
You said the pace. The pace at which, and then
exactly.
And he could have exercised.
That was what Felix said. He wouldn't have responded the way he did.
You said he could have exercised discretion in the pace, and he is making the point that is not stated in the Constitution as you say you have read it. The president is bound to take action.
Good, but when he takes it, it's up to his discretion.
Let me bring in Solomon Owusu. He is a member of the Movement for Change. He's also a political analyst. And Hesse Mam is still with us. He's a private legal practitioner. Mam Hesse, is that position espoused about the discretion of the president even founded in law? Does it have any definition whatsoever or grounding in the law as stipulated in Article 146? Hello, Lawyer Hesse Mam? If you can unmute for me. Can you hear me?
Oh, no, I've not muted.
Yeah,
Can you come by your question again?
I was asking that, does that position about the president exercising discretion as to how quickly or otherwise he submits or refers petitions received to the Council of State grounded in law or the dictates of Article 146 as you do know it?
Okay, if I hear your question well, Are you asking about the time as required? Because I hear Dr. Zato making that
exactly.
proposition.
Yes.
Is that what
yes.
you're asking?
That's the point that he was making earlier. Yes.
I mean, just as I submitted early on, the constitution does not provide. You see, these are minute details, you know, and the constitution does not deal with the minute detail. It deals with broader constitutional provisions, and the constitution under Article 1467 indicates that the recommendations will be made to the president, and the president would act on it. Definitely, the president would act on it with advice from the Council of State. It does not give that framework of time within which this would be done. And so, given the fact that the president has satisfied this constitutional provision, it could go ahead to act on it. I mean, it is a discretion of the president to decide to wait a day after, 2 days after, 3 days after. But at the end of the day, once the president acts under the details of the constitution, there's no infraction or whatever. But like I said, in the political theater, a lot of political inferences could come in, but once it's legal or under the law is direct and is positivist. So what the law says is what will be done, and that's what the president has done.
All right, and stay with me because Ms. Solomon, also can you hear me? Good evening, thank you for joining us. And this is the decision of the 5-member committee as communicated to us by the statement by Felix Kwachofosu, whom we just spoke to, detailing exactly what the committee's recommendation was upon the first petitioner, Daniel Ofori's petition. They recommended the removal of the Chief Justice, which the President has acted upon on the basis of that's stated misbehavior as one of the 3 grounds for the removal of the Chief Justice, as we've seen. Did you see this coming?
Yes, I saw it coming, and some of us advised. You remember on numerous occasions, some of us attempted the Chief Justice to go and negotiate a way out. But unfortunately, she had bad counsel. She had people around him who, to us, it were turned this to political, and that is why she got herself entangled in some of these days. This Ofori, people do not know the astute businessman in this country. He does not just get up. He's not someone that you can be pushing around. He raised 21 issues of misbehavior and 4 issues of incompetence. Who would do that and think that the Chief Justice get away with it? He was on solid grounds, and it was the reason why some of us said, look, we need to protect women in public space. So, madam, go and negotiate your exit and let us have peace. Take a cue from aid for task of the U.S. in the 1960s and also walk out on Nigeria in 2019 and then get off the radar. She did not listen to anybody. Nothing the president did that does not conform to the constitutional provisions that you operate with. The president has operated within the constitution. A petition was sent. He received a petition in consultation with the Council of State. With the Primma facie, a committee was established. Throughout the process, when the matter was supposed to be heard in camera, we had the Chief Justice supposed to know the law, flout it, come into the public space, hold a press, take the country into ECOWAS court, take us to Supreme Court, take the country High Court. All these processes have been gone through, and if the outcome is she be removed and the president has acted, I think we have to rather clap for the president rather than saying otherwise.
I see. But then also, we'll see this particular issue of the politics of things being read into it. We've had the law also at play, as explained by the lawyers, about what exactly has resulted in this decision as we are seeing now. You seem to have a clear knowledge about who the first petitioner is. But this 5-member committee looked at the petitions and then also made their decision and recommended what they did to the president. In fact, from what we do know, the Chief Justice testified and was cross-examined. She called 12 witnesses, including experts. The petitioner, Daniel Ofori, also had evidence from 13 witnesses on behalf of the petitioner. And then the panel received approximately 10,000 pages of documentary exhibits from both sides. That's according to the details as we do have it from this committee's work that has resulted in this particular decision. Mr. Uzu.
I mean, that's but the petitioner knew what he was about. He was not one of those that just will level against someone without evidence. He took off with to the committee with evidence to prove his case. And I think we must encourage some of these things. I am not of those. I'm not one of those that believe that it must be too difficult to remove people in the position. And we must not also take those who are saying it's a political which aren't serious, because the very position of the Chief Justice is a political position. If the Chief Justice is not appointed by the President, it makes it a political position. And so, it has its own political dynamics and legal dynamics. I'm saying the legalities. There is no lawyer in this country who has been able to convince me that due process is not followed, right from the beginning. So, well, I think there was anybody that supported provisions in the Constitution, justice. When matters were to be happening, she decided to come into the public space to hold a press conference and expose what was going on committee posts. I thought that was fun. And so we have gotten to a stage where a decision has been made and she's removed. And we move on as a country.
I thank you, Mr. Solomon. Also, thank you as well, Dr. Joshua Zato. Thank you, gentlemen. Thank you for joining us. And lawyer Christian Mamhesi, Dennis Barberi Wadam Esquire is also going to be joining me in a bit. We'll get a bit more into how the path has been up until this point, a decision that has been taken. If you're just joining us here on TV3, also live on 3FM 92.7, the breaking news that we've been getting into, we brought to you almost an hour ago and over, is that the President, John Dramani Mahama, in accordance with Article 1469 of the 1992 Constitution of the Republic of Ghana, has removed the Chief Justice, Her Ladyship Justice Gertrude Araba Esaba Saki Tukono, from office with immediate effect. Now, this follows receipt of the report of the committee constituted under Article 1466 to inquire into a petition submitted by a Ghanaian citizen, Daniel Ofori. After considering the petition and the evidence, the committee found that the grounds of stated misbehavior under Article 1461 had been established and recommended her removal from office. Under Article 1469, the President is required to act in accordance with the committee's recommendation. This is what has resulted in this decision, as we're saying now, by His Excellency the President of the Republic of Ghana, John Dramani Mahama. And then, as we did indicate earlier, this committee has been at it for quite a while now, getting to know the details that the Chief Justice, in fact, also testified and was cross-examined, and she called 12 witnesses, including some experts as well, as per the details as we have it from this committee's work.
Yes, that's right. Including over 10,000 documents that have been submitted by way of evidence by the petitioners and also by persons who have appeared before the committee to testify in support of the now removed Chief Justice. But Alfred, now many are asking the questions. Does that mean the country is without a Chief Justice? Yes, we don't have a substantive Chief Justice, but we do have a Chief Justice who is in acting capacity.
Right.
You do recall that following the suspension of the Chief Justice, or now removed Chief Justice,
yes,
the most senior Justice of the Supreme Court became the acting Chief Justice, and that's Justice Paul Bafo-Boni, who has been in acting capacity. It also means that until a new Chief Justice is appointed, he will continue to hold the fort and perform the functions of the Chief Justice as administrative head of the judiciary and also as a Justice of the Supreme Court as well. So those are matters that many are looking forward to how the coming days are going to look like in respect of who gets to become the substantive Chief Justice.
I see. Now, on the question about this process and whether the President has any leeway to exercise discretion, okay, because the process is entirely constitutional,
yes,
and is stipulated in the details or dictates of Article 146, all the way from clause 1 to about 10 or 11. We've been running through it,
yes,
all the while. Let's just, for the benefit of some education to our viewers, let's go back a bit, okay? Let's see from the point where the President receives the petition, okay? Does that give him any leeway to apply discretion as to the time he forwards the petitions to the Council of State?
Right. So when you look at Article 146, which is the law that has been used for this whole process, it gives a clear overview as to how proceedings under this provision should look like. 1461 says that a justice of the Superior Court or a chairman of a regional tribunal shall not be removed from office except for stated misbehavior or incompetence or on the grounds of inability to perform the functions of his office arising from infirmity of body or mind. This clearly states the grounds for removal of such persons. In this case, we are talking about the Chief Justice. But mind you, Alfred, when you look at the provisions under Article 146, you would find that it does not mention the Chief Justice. It only talks about justices of the Superior Courts, and the Superior Courts include the High Court, the Court of Appeal, and the Supreme Court.
Yes.
However, in the case of Frank Ejechum, the Supreme Court held that to the extent that a Chief Justice is first and foremost a Justice of the Supreme Court, this process should apply. And that's the main reason you don't see that you have a Chief Justice categorically mentioned here, yet this is expressly stated, yet this is the procedure that's adopted for the removal of a Chief Justice. Now, 2 says that a Justice of the Superior Court, in this case, let's substitute that with Chief Justice, may only be removed in accordance with the procedure specified in this article. Emphasis. May be removed only in accordance with the procedure specified in this article. What it means essentially is that for any removal of a Superior Court Justice or the Chief Justice in this matter, no other procedure should be adopted except one which has been specified under Article 146. Now, the 3 says that if the President receives a petition for the removal of a Chief Justice of a Superior Court other than the Chief Justice, or for the removal of the chairman of a regional tribunal, he shall refer the petition to the Chief Justice, who shall determine whether there is a Primma facie case. This refers to justices of the Supreme Court other than the Chief Justice himself or herself, depending on who is there. And recall, that was how come when a petition was presented for the removal of Justice Primma, it was forwarded to the Chief Justice for a Primma facie case to be determined.
Absolutely.
That petition was later withdrawn. True. If it had proceeded, what it meant was that it would have been the Chief Justice, Her Ladyship Justice Gertrude Tukono, who would have looked at it to determine whether or not there's a Primma facie case. However, that petition was withdrawn. Now, 4 says that where the Chief Justice decides that there is a Primma facie case, he shall set up a committee consisting of 3 justices of the Superior Court or chairman of the regional tribunal or both appointed by the Judicial Council or 2 other persons who are not members of the Council of State, members of Parliament, nor lawyers, and who shall be appointed by the Chief Justice on the advice of the Council of State. So this now begins to speak about where a Primma facie case has been established, for which what should follow.
Right.
We had seen that happen, and that was the beginning of all the troubles, including the legal challenges that came. Absolutely. Because the first statement that had come from the presidency was to the effect that some petitions had been presented, which were forwarded to the Council of State, and they were looking into for the determination of a Primma facie case. Let's look at what 5 says. That the committee appointed under Clause 4 of this article shall investigate the complaint and shall make its recommendations to the Chief Justice, who shall forward same to the President. This is a procedure for the removal of a Justice of the Supreme Court, for which, if a Primma facie case is determined, this will be forwarded to the President. Now, let's look at what 6 says in respect of the Chief Justice himself or herself, depending on who is there. Now, we are looking at it in generic terms.
Absolutely.
Where the petition for the removal of Chief Justice, the President shall, acting in consultation with the Council of State. The President shall, acting in the Council of State.
Yes.
That is very important.
And it's important to put the emphasis there, because it answers Dr. Jastot's question.
Yes, and many who share in the
others.
light of how that should be done.
Okay.
And also imparts the concerns that Vincent had, for which he went to the Supreme Court.
Absolutely.
Asking the Supreme Court to make a determination as to what should come first. Now he says that where the petition is for the removal of Chief Justice, the President, acting in consultation with the Council of State, shall appoint a committee consisting of 2 justices of the Superior Court. In this case, we have seen the appointment of Justice Primma and then we have seen the appointment of Justice Asedu, who are Justice of the Supreme Court, one of whom shall be appointed chairman. So it is automatic that one of the two Supreme Court justices appointed would be the chairman, and that informs the reason that Justice Primma was chair of the committee by the president. And the three other persons who are not members of the Council of State, so those three other members, including the former Auditor General that you see on, they are members who are not members of Council of State, they are not members of Parliament, and they are not lawyers.
Absolutely.
So in other words, you can say they are laymen.
Absolutely.
Or women.
Yeah.
7 says that the committee appointed under Clause 6 of this article shall inquire into the petition and recommend to the President whether the Chief Justice ought to be removed from office. This is what we saw earlier in the day, where after the committee had looked into the petitions, they have made recommendations by way of a report which they submitted to the President, by way of giving an insight into what the committee looked like and how the processes went. The chair of the committee did indicate that there were 13 witnesses testifying for Daniel Ofori. There were 12 persons testifying for the now removed Chief Justice, including experts, well over 10,000 documents by way of evidence, 4 lawyers on each side.
Think about
Just
it, over
giving
10,000
documents.
documentary evidence.
Yes.
That's quite some work.
That's quite some work to be done on just one petition. Imagine they were to do all the three petitions.
Kingsley J of Shining Stars.
Exactly.
And then ACP Ayamga Yakubus Akolgos.
Precisely. But recall, there's a matter that the Chief Justice has in court in respect of Shining Stars.
Absolutely.
Challenging the legal existence of that entity called Shining Stars. That matter is still a matter that the substantive leg is on, but the High Court has yet to make a determination on whether or not the Shining Star actually exists in law or exists in fact. But with the turn of events, one wonders what the future of that particular suit to be. But for purposes of record, it's just important that these processes should be allowed to go to their logical conclusion. So we see how things pan out. Let's get back to the processes under Article 146.
Right.
Now, it says that all proceedings under this article shall be held in camera, and the justice or the chairman against whom the petition is made is entitled to be heard in his defense by himself or by a lawyer or other aspect of this choice. Now we are told that the Chief Justice in her defense, she had 4 lawyers. The petitioners had 4 lawyers on there. We are also told that, yes, we know for a fact that all the proceedings were in camera. It is the reason for which some of the averments that the Chief Justice put in some of the affidavits she wanted to use in court were rejected.
Yeah.
The reason being that the proceedings are supposed to be in camera. 9, the President shall, in each case, whether it relates to a Justice of the Supreme Court or a Chief Justice, act in accordance with the recommendations of the committee.
Right.
And that is what we are just been told, that the President acting in accordance with the report that was submitted to him hours ago has gone ahead to remove the Chief Justice from office. Now, there's also a part which comes in between as the process is ongoing. The 10, that where a petition has been referred to a committee and that this article, the President may, A, in the case of the Chief Justice, acting in accordance with the advice of the Council of State, by warrant signed by him, suspend the Chief Justice. This in itself also became a controversy.
Yes.
When the President invoked Article 146(10) to suspend the Chief Justice. And that also forms part of the reasons some entities, including the GBA and also international bodies, also coming in to add their voices that this particular suspension was not...
And you know, the Chief Justice had, the now sacked Chief Justice had a concern that she couldn't tell explicitly whether the copies of the petitions against her that were given to her are the same copies that the committee members had before them for the entire hearing.
Yes.
Based on the dictates of this particular provision, can it ever be the case that the committee would be giving different set of details of the petition from what the Chief Justice or the now sacked Chief Justice was giving while the process was ongoing?
Well, so the point she basically made was more procedural, to say that appearing before the committee ought to have furnished her with the documents that they were working with.
Mm-hmm.
But that was her allegation. That has not been proven anywhere. That has not come out as a matter of fact that the petitions that she had were different from the petitions that the committee was working with. And if you also recall, when this matter came up, in a number of the suits that we have seen, we did not see anywhere that indeed it was a matter of fact that what she was saying was true. In fact, the Attorney General, in almost all the suits that we have seen, the Attorney General opposed, did indicate that as far as they are concerned, she has all the documents that she's required to have by law.
Including the full details of the petitions.
That could include that. But the Attorney General has always maintained that she was given all the documents that she is required to have in law. So that could possibly include the petitions in this particular one. Now let's get to the very final one.
Right.
This never happened, but it could have happened. And it flows from the 10 where the president is given the power to suspend while the process is ongoing, that the president may at any time revoke a suspension under this particular act. And this is very instructive because when you hear the call of the GBA and the like who were calling for the revocation of the suspension of the Chief Justice, they were only urging on the president to come under this particular provision because the law allows the president who has activated 14610 to, at any time, activate 14611. And that is the basis for which
he could have
such
revoked
strong
the
calls. Yes, he could have revoked the suspension. So that's the entirety of Article 146, and that's the procedure that this whole proceeding has gone through, despite that there are numerous challenges. But when you look at it closely, Alfred, you can tell that one thing which is missing here is timelines. It does not tell for how long a petition should be before the president before it is forwarded to Council of State. It does not tell how long it should be there before a prima facie is determined. It does not even tell how long a committee, which is seized with the power to look into that petition, should run. So this committee has spent so much time only for us to be told it looked into one petition. What it means is that it could have actually gone the whole year.
Or the whole year, absolutely.
There are no timelines.
True.
Earlier in the day, Kamini was asking if the president, upon receipt of the report from the Council of State, as in the final report, he was bound by timelines to make an announcement as to when to act on it. That is not also provided.
In this.
So Learned Counsel earlier mentioned that the Martin Pebu mentioned earlier that the Constitutional Review Committee should begin to look into some of these things
areas.
to make, some proposals for amendments. And that's a conversation that we can carry on.
Certainly, and he has made that call that the details of this committee's report on which this decision was taken should be made public so that we all get to know what the committee found in the case of Daniel Furey's petition, on which they now established stated misbehavior, upon which the president took the decision upon the recommendation of this committee. So that's one other call as well that we'll see whether the coming days the committee's report will be made known to us. But let's quickly recall exactly what the sacked Chief Justice's position was on this entire process during that press conference that she addressed. Take a look.
Unfortunately, every step of the removal process being undertaken against me is being done in a manner that breaks every rule on how justice is delivered in our country. And this is why I find the need to draw the nation's attention to the serious violations of the Constitution and law in the process, and the danger it holds for the development of the nation's democracy. I applied for the proceedings of the committee set up by His Excellency the President to be held in public, so that in the interest of transparency and for the truth in the matters being raised to be made known to the people of Ghana. I did so because I knew that the secrecy of the proceedings for removing justices was not created in the Constitution as a cover-up for any agenda. The Constitution expects that only reasons for removing the Chief Justice and public officials as set out in Article 146 will be the reason for doing so. And especially, such reasons must affect public sensitive national interest or public order or safety. Resigning or retiring while Article 146 proceedings are being conducted to remove a judge is not an option any judge or public official can even have. There is a decided case on the matter by the Supreme Court. The suit number is J6/02/2019.
So these concerns were certainly responded to by Justice Propama during the presentation of the committee's report to the president not too long ago, just a little over an hour ago. And this is what he said. Take a look.
Ladies and gentlemen, Mr. President, in March this year, you received 3 petitions pursuant to Article 146 of the Constitution 1992 for the removal of Chief Justice Gertrude Asaba Araba Sakitokon, and the public was made aware of these facts. Subsequent processes dictated by the Constitution and the decisions of our Supreme Court were gone through, culminating in the establishment of our committee under Article 146, Clause 6 of the Constitution. The nation was further duly informed, and when we commenced our work on the 15th of May 2025, the Minister of State for Government Communications was briefed and notified the public about it. There has been considerable interest in our work, shown through comments and opinions by Ghanaians and international observers as well. However, the committee restrained itself all along from reacting, even when blatant false statements were made about members of the committee and our work. To the committee, our mandate and remit is set out under Article 146, Clauses 7 and 8 of the Constitution. It's clear, and it is to inquire into the petitions in camera. Here, the person against whom the petitions have been brought in her defense by herself or by her lawyer or other aspect of her case, and then make a recommendation to you, Mr. President. As I have said above, 3 petitions were referred to us, and though all 3 petitions seek the same relief, each petition is distinct and would succeed or fail on its individual strengths or weaknesses. Mr. President, without disclosing the substance of the proceedings, and since in-camera proceedings is not the same as in secret, we can state that in respect of the first petition, we received evidence by Mr. Daniel Ofori, the first petitioner, through 13 witnesses. Similarly, the Chief Justice in her defense called 12 witnesses, including expert witnesses, as she is entitled to do under the Constitution. The Chief Justice testified personally and was cross-examined. The committee received about 10,000 pages of documentary evidence from both sides.
So that's Justice Gabriel Scott Palmer, who is the chair of this 5-member committee established as per the demands of Article 146 of the 1992 Constitution, upon whose recommendation the President has taken the decision to sack the Chief Justice, her leadership, Justice Gertrude Araba Esabasaki Tukono, from office with immediate effect. And this was just upon the details of the petition by Daniel Ofori, one of 3 petitions that the committee was tasked to actually look into or hear. We had over 10,000 documentary, as it were, evidence we saw as per the details of the chair's earlier input, and then also the over 13 witnesses on both sides, as well as 4 lawyers as well testifying on both sides. And it's one that this is a matter that we will see play out in the coming days. Then it's because there are a couple of cases as well that are still running.
Yes, quite a number of
this case.
In fact, all the substantive cases that are before the Supreme Court, we haven't heard any of them has been withdrawn. What it means is that they are still pending, for which the Supreme Court is supposed to make a determination on. Clearly, some of them will possibly answer the questions that were raised by way of timelines and also by way of what actually constitutes, at what point can information be made available to the public or not. Justice Palmang, in that particular sound clip, makes an instructive comment about the process being an in-camera, but the process not being secretive. All those are matters that, in the coming days, we probably will get clarity if the judgments of the courts in respect of those cases begin coming out one after the other. There's a lot more to talk on this particular matter, Alfred.
Indeed.
But I'm sure on News 360 and subsequently Ghana Tonight, we'll be back again to do more on this particular issue.
And make some time with us on this. Dennis Baberi Wadam is a private legal practitioner and then also with us here on our legal desk. And he's going to be with me at 10 p.m. on Ghana Tonight, together with a few other persons who will be joining us. So stay with us on TV3 and across all media journal platforms. On behalf of the rest of the team, I want to say thank you for staying with us. I'm Alfred Okanse. I did this with
Dennis Wedam Paberi, Esquire. You like to hear that from me?